evidence and discovery comes in.
All right, Alex Capriello joining us live. Thank you. All right, let's bring in now SARA AZARI, NewsNation legal contributor and a criminal trial attorney. Sarah, thank you so much for your time. So hearing this, it kind of brings to mind the OJ defense, right? The evidence was planted. The police were out to get OJ. Is that what the defense is trying to say here?
Yeah, Nicole, good to be with you. No, it actually isn't. This is all coming from the prosecution's responsive paperwork that's really hyperbole and fodder for the media. What the defense has said is that his DNA was placed at the scene, not planted. And this is not a matter of semantics. It's a matter of science, because the only DNA, Nicole, at the scene was this touch DNA on the knife sheath. Touch DNA, as we all know who do the job, is the most unreliable type of DNA because typically it's transferred. And so what the defense is really saying is that it doesn't tell us that Brian Kohberger was there. It doesn't tell us how his DNA got on that knife sheath. And really the larger picture of this is that there's been this point of contention about the investigative genetic genealogy material that the prosecution does not want to produce, that the defense wants to be discovered. And so that touch DNA, because it was part of what ID'd Kohberger, goes to those materials as well. So again, I think this is about the defense saying it was transfer DNA, touch DNA, and the prosecution trying to make it to be some sort of a red herring, like, oh, you know, they're claiming it's rigged. But is it possible that law enforcement plants evidence? Absolutely. It's happened in my cases. And this was a very high profile case. There was pressure to make an arrest. It's not implausible that things could have been planted. It's just not what the defense is saying here.
So, Sarah, I want to expand on that a little bit. So the defense, there's this matter of semantics, you know, placed versus planted. But then what about the video evidence? You know, he was allegedly caught, or at least his vehicle was allegedly caught on surveillance video. There's cell phone data that places his cell phone in the area, right? Is it telling that the defense team is not addressing any of those issues? At least not right now.
Yeah, not right now. Exactly. Yeah. And no, because there's so much, I don't know how many terabytes of discovery already produced. The defense is still going through it, consulting with experts. And remember that in a circumstantial case, the prosecution is building their case, and the defense's job is to dismantle that case. And so it's not about any one sort of piece of evidence that we can just focus on out of context. We have to look at each piece and the reliability of each piece. So with respect to the cell phone pings, was it reliable that his phone was pinged by these towers? I can tell you I've had clients who were over 20 miles away from the tower that was pinged, and their phone got pinged. You know, the car, there was problems with the identification of the car. First it was 1 year, then it was a different year. And, you know, so when the jury sees this case, they're going to have to take a look at really the reliability of the totality of all of these pieces of evidence. And if I just may address what Alex said about the alibi, Nicole, you know, it is not extraordinary that he doesn't have an alibi. It's in fact very normal that he doesn't have an alibi. How many of us can produce receipts that we were in bed at 4 a.m. on a specific night or morning? We just can't. And so what he's doing is essentially saying, at trial, we will show you that through cross-examination that the prosecution has not been able to prove that Kohberger was at the Kings Road home and that he committed the murders. Essentially, they're saying we don't have an alibi yet, but we can show you that he wasn't there through the process of trial.
So Sarah, to expand on that a little bit, so they have not formally submitted this alibi. They're asking for this extension on doing it. But what does that say to potential jurors who, you know, have yet to be seated, who more than likely, you know, are still seeing all of this coverage right now, just like the rest of us are? Could that be detrimental down the road?
I think everything about this case is detrimental to eventually a jury that's going to be seated in the box, because I hope that those jurors are critical thinkers, that they're open-minded, that they believe in the presumption of innocence, and that they could just take what the evidence is in that courtroom and not what they've heard for all these months. It's not an easy job to do, but it's what they must do. And, you know, he doesn't have an alibi because there's so much discovery. It's massive. And the defense doesn't even have everything it needs to then be able to do its own investigation, number one. And number two, most people don't have an alibi. And so does that mean just because he doesn't have an alibi that he's guilty? Absolutely not. You can get acquitted without an alibi. So again, I think that Ann Taylor is just as much providing fodder for media as the prosecution is in this case by saying, instead of saying, oh, we don't have an alibi, she's saying, well, we're going to show you a trial. Well, that is the process of trial. So it's traditional alibi means you actually have proof, because it shifts the burden to the defense, that you were someplace else. We don't have that yet. And if they're going to produce that down the road, Nicole, they're going to have to get a court order that allows that delayed alibi, because the prosecution then needs time to investigate it.
Really quickly, do you think this trial starts in October?
Absolutely not.
All right. Very simple. There it was. All right. SARA Azari, News Nation legal contributor. We thank you so much for your time.
Good to be with you.